Arunjeev Singh, Barrister from New Zealand. Today, 17th of July 2025, I am going to share with you some salient features of the Immigration, Fiscal, Sustainability and System Integrity Amendment Bill 2025. This bill has been introduced in June 2025 in the New Zealand Parliament by Honourable Erica Stanford, Minister of Immigration in New Zealand. The purpose of this amendment bill is to improve the fiscal sustainability of the immigration settings. So it will add power to the immigration minister to impose immigration levy to few other class of sections of people or organizations apart from the people who apply for a visa. So it means that today when immigration levy is payable by only the applicants for a visa, but with the proposed amendment, immigration levy could be imposed on employers who intend to support work visa applications for migrant workers, and immigration levy could be imposed on educational institutions where international student will be allowed to study as a full fee paying foreign student. So in crux, the purpose of this amendment bill is to give more powers to the Minister of Immigration and New Zealand government to impose levies and to have more powers in respect of certain classes of visas and for deportation or issuance of deportation liability notice to some classes of visa holders in New Zealand. So in terms of the imposition of immigration levy, the employers would be required to pay some immigration levy on the top of any other fees which are payable by the employers. Like under the accredited employer work visa scheme, the employers have to pay fees for getting accreditation and then getting job checks and getting the job token issued by the Immigration New Zealand. So then there is another important amendment proposed for amendment to section 161 of the Immigration Act 2009. So currently section 161 says a residence class visa holder is liable for deportation if he or she is convicted in New Zealand or elsewhere. But with the proposed amendment, it will be replaced by a residence class visa holder is liable for deportation if they plead that they are guilty or found guilty or are convicted in New Zealand or elsewhere. So it means that a person who is the holder of a resident visa may be liable for deportation simply because he has been charged, and if he pleaded guilty or if he is found guilty after a trial or if he is convicted. So earlier, only deportation liability notice for a resident visa holder applies when he is convicted by a court. But with the proposed amendment, even if a person has not been convicted, still because he has been charged or he has pleaded guilty, that would make him liable for deportation under section 161(1). Section 351A, which relates to exploitation of victims by charging premium for employment. So subsection 1 of this newly added 351A goes as: every employment related person commits an offense against this act who knowingly seeks or receives any premium in respect of the employment or potential employment in New Zealand of a victim. Subsection 2 states, subsection 1 applies before and after the victim commences work in New Zealand and whether or not the victim commences work in New Zealand. In this section, a person is a victim if they are domiciled in New Zealand or are overseas based and are one of the following: an unlawful worker, a temporary entry-class visa holder, a potential temporary entry-class visa holder, a potential residence class visa holder. So this subsection includes people who have never traveled to New Zealand, still they can be accepted or called as a victim because they are a potential temporary entry class visa holder. In this section, employment related person means a New Zealand based employer or potential employer of a victim, a New Zealand based agent of an employer or potential employer of a victim, a New Zealand based person involved in the recruitment of a victim for employment or a potential employment in New Zealand, a New Zealand based person who has dealt with a victim in that context of the victim's employment or potential employment in New Zealand. So it means the employment related person who can be charged under this section 351A could be either an employer or a potential employer, or could be an agent of the employer or potential employer, or could be a person involved in the recruitment of a victim for employment or potential employment, and a New Zealand based person who is not even an employer or an agent but has some involvement or dealt with a victim in the context of victim's employment or potential employment in New Zealand. So this has widened the scope of people who could be charged under this new section 351A, and the definition of victim has been expanded to include even people who are not in New Zealand. Now, New Zealand based means a person who is a New Zealand citizen or a person domiciled in New Zealand, whether or not they hold a visa. Overseas based means a person who is not in New Zealand based. Potential residence class visa holder means a person who seeks to hold a residence class visa and seeks to obtain employment in New Zealand and is required to be employed in New Zealand in order to be granted a residence class visa in accordance with immigration instructions certified under section 22. Potential entry class visa holder means a person who seeks to hold a temporary entry class visa and to obtain employment in New Zealand. Temporary entry class visa holder means a person who holds a temporary entry class visa. Unlawful worker means a person who undertakes or seeks to undertake work that the person is not entitled under this act to undertake. So this means that section 351A has brought many people within the definition of victim or within the definition of exploiter or a person who has committed such an offense. So section 351A seems to be criminalizing the relationship between an employer and an employee. Apart from the Minimum Wages Act and Wages Protection Act, this section 351A imposes a punishment of 7 years imprisonment or $100,000 fine, or with both, to a person who is found guilty under this newly proposed section 351A.